What are you talking about?
Sorry, Your Honor. Her name was entered incorrectly into Zoom, and I wanted to make sure that wasn't a maiden name or something.
It was entered incorrectly by my staff?
I'm not blaming anyone.
Assistant Public Defender, should I be?
Blaming you?
Yes.
He is?
Right. So.
Oh, don't say that. Don't save him. Speaking Behringer had it all mixed up.
Oh,
Had it all straight. Don't worry about it.
that's cold. Did you just say Behringer?
Mm-hmm.
That's cold.
Call my staff out. I'll call it. All right.
Tell him.
To the table.
Never did that.
I'm glad. What?
You never did that.
There's a reason. Go ahead, Mr. Cook.
Your Honor, the people who believe any potential conflict between this honorable court and the office of the public defender, while the people do not believe that conflict exists, we make this waiver and the avoidance is called out.
Thank you.
Ready, Judge. Marshall, please, the first assistant public defender. Judge, we likewise do not believe that a conflict exists before this honorable court, but should a conflict arise, we would waive any conflict on any and all cases before this honorable court today, and ask the court to please hear those matters.
Court for its part also does not believe there's conflict either in the Michigan court rules. Other cases decided there under the extent of conflict does exist. Given the waivers, the court will consent to hear the matters. Court does call the case, People State of Michigan versus Michael Bank.
Assistant Public Defender Davi Lebo for Mr. Bank. And good morning, Your Honor.
Mr. Bank,
Yes, Your
can
Honor.
you state your name? Can you state your name, please?
Michael Bank.
Thank you.
Your Honor, I'm going to be requesting an adjournment. I believe maybe the last adjournment we'll be requesting. I was trying to meet with Mr. Bank yesterday, but we had some technical issues over Zoom, so I'm going to be going up to Oakland County to see him in person again.
Where is he?
He's in Oakland.
Oakland. You gonna be able to get it accomplished in 2 weeks, or you need 3?
I can't imagine it wouldn't be possible in 2 weeks, Your Honor.
It would be
Absolutely.
June 4th. Probable cause conference will be adjourned June 4th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you, Mr. Bank.
Thank you, Your Honor.
Court calls the case, People versus Mohammed Dayan.
Your Honor, for tonight, it was talking about the fifth part of Michigan Code, so like one, two, three.
Michigan what? Did you say court rule or code rule? Oh dear. Start over. Start over. This is gonna be a long day.
Michigan Court rule, like one, zero, under supervision, you heard the attorney actually.
Tell you to say code? Yeah, just say yes. You're not gonna do it, are you? Permission to practice is granted.
Assistant Public Defender Davi Lebo for Mr. I'm sorry, I'm blinking on the name suddenly. For Mr. Dayan. A little distracted.
No, it's okay.
Mr. Dayan, can you state your name?
Mohammed Dayan.
Thank you.
Your Honor, I've been in some discussions with the prosecutor about this case. I need to have another visit with Mr. Dayan to update him on those discussions, please.
Can you get that done in 2 weeks?
Absolutely.
Probable cause conference will be adjourned to June 4th, 2026, 9 a.m.
Thank you.
I'll continue. Thank you. Thank you, Mr. Dayan. Court calls the case, People Moses Frazier.
Thanks, Kennedy, for the Your Honor.
Did they put their, I didn't hear if they put their appearance on.
They did hours ago.
Thank you. Good morning, Your Honor. Marcia Creech on behalf of Mr. Frazier. Mr. Frazier, can you please state your name?
Moses Frazier. Thank you.
Your Honor, we'd be requesting continuing to preliminary exam. Discovery is complete.
Discovery is complete.
Yes, sir.
And would the people have their witnesses? What they do? People have their witnesses available June 2nd. Right. Preliminary examination will be set June 2nd, 2026, 9 a.m. before Judge
Judge Perry.
Judge Perry.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls the case, People versus Justin.
Your Honor, was that Justin Chaps?
No.
I'm sorry.
Really? Can't hear me? Can it? You can't, it's you. Good. Thank you. Your name, sir?
Justin Heaton.
And sir, you are intending on representing yourself?
Yes.
Pardon?
Yes.
All right. I do have to advise you that a couple of here on 2 counts of assaulting, resisting, or obstructing a first responder or police officer. You understand that, sir?
Yes.
Both of those are felonies punishable by up to 2 years incarceration, a $2,000 fine plus court costs. You understand that?
Okay.
Right. If at any time during this procedure you wish to be represented by an attorney, all you have to do is ask the court, and the court will be more than happy to make sure that you are afforded counsel. You understand that?
Yes.
Do you still wish to proceed on your own? All right. What would you like to do in this matter?
Well, I was hoping to see if you were able to remove me from the jail today.
You're asking me to reduce your bond?
Yes.
Well, even before I get there, I have to do something with the case. What would you like for me to do with the case, sir?
Well, seeing as I was hoping to be removed from the jail so that I could better prepare for the case, that was my best wishes.
You don't know what procedure comes next in this process, do you?
I assumed it was on the court. Yes.
Pardon?
I assumed it was on the court to decide that. Yes.
On the court.
To decide the next procedure.
Sir, do you want to be represented by an attorney? If for no other reason than to assist you in this matter, I have some serious concerns that you're not sure what you're doing. And I'm not saying that in a bad way. I just don't think you know what you're doing.
Okay.
Okay, what?
No, thank you.
Okay.
I thought that I stated my claim fairly standardly.
Do you want a preliminary examination in this matter?
I was just speaking to my best wishes.
The next thing that will happen is the preliminary examination when the case is ready to go. Are you ready to have your preliminary examination?
Proceed.
Pardon?
Proceed.
Proceed. What's that mean?
I'm ready to proceed.
You're ready? Have you seen the discovery in the case?
The only paperwork I have is right here. It's the
Your Honor, our office has not really been able to deliver just summary. We would be asking for at least one of the jurors to make sure Mr. Heaton has studied. Right.
Understand that, sir? You haven't seen the paperwork in the case, right?
this is the paperwork that I did request proper paperwork before today. Yes.
You requested it from whom?
From the jail upon.
From who? All right, sir, you haven't seen a police report or anything like that, right? So you don't know the particulars of the allegations of the charges here. That was a question. You don't understand that, correct?
I would just not like to answer.
Would you like a copy of the police report?
Before we proceed with the case today,
At any point? Sir, I'm going to ask you again, do you wish to be represented by an attorney?
no.
All right. What I'm going to do, however, is I'm going to, out of fairness, grant the request of the people to adjourn this matter. How long will it take the people to get paperwork to him so that he can be as prepared as he would like to be to proceed to exam?
We will get that over as soon as we can. My understanding, there are also videos that may take a little bit. Longer.
Well, I'll give you two because they're gonna have to arrange a way for him to look at it, and I don't. Probable cause conference, court's gonna find good cause to do so. I'm going to adjourn that to June 4th, 2026, 9 a.m. Bond in this matter will continue. Thank you. So that we're clear on denying the request to release the defendant at this time.
Literally told me not.
Court does call the case, People versus Lewis Gaines III.
Your Honor, Raymond Cook for the
Cases.
Good morning, Your Honor.
On behalf of Mr. Gaines, who's appeared by Zoom, as I understand.
Mr. Gaines, can you state your name, please?
Louis Gaines III.
Thank you, sir.
If I may, Your Honor?
Yes.
Your Honor, we were set to do a plea today. I met with Mr. Gaines yesterday. Then I came here this morning and was informed that Mr. Gaines was not brought up. I don't know the circumstances of why he was not brought up. I'm concerned that he has destabilized at some point so that where I don't feel comfortable going forward with the plea at this point. I'm asking for a 1-week adjournment.
Probable cause conference will be adjourned to May 28th, 2026, 9 a.m. Both cases.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Tanisha Moore.
Your Honor, Raymond Cook for the people. Your Honor, William Thomas, 76194 on behalf of Miss Moore. Who will be to my right.
Thank you.
Judge, we did have a plea in place. I did not get it done in time and I apologize for that, but we finalized the plea after 10 a.m. yesterday. I'm going to ask for a 1-week adjournment. Well, here's why, Your Honor. I know, see that quizzical look on your face. I don't want to get.
No, that's how I look. Sometimes.
Here's what happened, Judge. There were a few different files. The people did agree not to issue on another case. She's going to plead to 3 misdemeanors. I'm asking for a 1-week adjournment. I'm asking her to let out on a PR bond and GPS tether. She's been sitting for 60 days. I did do a bond memo yesterday. I don't think the people are going to object to her being released on tether and come back in 1 week to do the plea.
Your Honor, I've released a bond ultimately to the court's discretion. I noted I made Mr. Hondo aware there was a hold on the for an A and B. I don't know if they're going to pick up on that, but just so the court's aware of that.
Or an A and B.
Yeah, in Detroit, I don't think that's going to happen.
Well, I don't know. It depends on what kind of A and B. All right. We'll adjourn the probable cause conference 1 week to the 28th. Where does the defendant reside?
Pearl Street.
Let them know.
I live on Pearl Street.
Pardon?
In Ipsy.
Pearl Street, Nipsey. They told me.
Or reduce the defendant's bond to a $10,000 personal recognizance. You understand that, ma'am?
Yes.
Defendant is to be placed on a GPS tether prior to release. That's GPS tracking. Heather, I'll adjourn this matter. If she's going to be out, then I will adjourn it to the 28th if you just wanted a week.
Yes, please. Thank you, Judge.
I just,
Contact your mom. She's got my contact.
Thank you.
whoa. Court calls the case, People versus Curtis Jones.
On behalf of the people, Your Honor.
Good morning, Your Honor. William Amadeo, P7619, for behalf of Mr. Jones, who is to my right. Curtis, please state your name for Judge Simpson in this court to know what issue.
Curtis Jones.
Your Honor, I was just put on these files. I'm asking for a 2-week adjournment. I don't know if this will be a waiver, but I'd like to discuss with Prosecutor Zenna, and we will waive all speedy trial rights. I do want to get familiar with the file before I proceed.
Probable cause conference will be adjourned to June 4th,
Thank you, Judge.
2026, 9 a.m. Bond continued. Court calls the case, People versus Kyle Purnell.
Reading the look at the deeply Your
Public defender for Mr. Pennell, Your Honor. Your Honor, I do have a green sheet if I may approach.
Next cards.
Of course, it's the one that didn't grab, right? Yes. State your name, Mr. Pennell.
Kyle Pennell.
And you're looking to adjourn?
Yes, Your Honor. I think there might be some video that we're still looking for.
Okay. Adjourn the probable cause conference will be adjourned June 4th, 2026. Next.
Thank you, Judge. All right.
Court calls case, People versus Tony Bailey.
Your Honor, bring the husband people.
What is that? You're on behalf of Mr. Tony, who is approaching.
Morning, Your Honor.
State your name for the record, please, Mr.
Tony.
Thank you, Judge. We were just able to establish some contact with Mr. Bailey this morning. I believe there's some video discovery and other discovery Mr. Bailey is hoping to thoroughly go through.
Thoroughly?
Thoroughly.
Okay, all right.
I believe he's requesting we would seek a 3 to 4 week adjournment.
4 weeks?
That's
That thoroughly?
that thoroughly.
Okay.
That's the request.
Probable cause conference, June 11th, 2026.
Thank you very much, Your Honor.
Thank you. Okay. Gotta give him that information.
Thank you, Judge.
Court calls the case, People versus Warren Abbott.
Warren Abbott.
Mr. Abbott, can you state your name?
Say Warren Taylor Abbott.
All right. Mr. Abbott, you wish to represent yourself?
Yes, please.
Okay, you don't want an attorney to help you through this?
I'm not sure.
Pardon?
Say I would like an attorney to help me, please.
You want an attorney to represent you on this matter? Is that correct?
Yes, sir.
All right. And at this point, this becomes a public defender case.
An assistant public defender, Jay Bellinger, on behalf of Abbott. Can I ask where Mr. Abbott is appearing from?
He's at our
Washtenaw County Jail? Okay, thank you. And Your Honor, at this point, I haven't had no opportunity to review the report. I would ask for a 1-week adjournment so that we can revisit this matter.
All right. So, Mr. Abbott, you're going to be represented by the public defender's office, and I'm going to adjourn your case out 1 week so they can get all of your paperwork and then come down and see you, okay?
Say yes, sir. And okay.
All right. Probable cause conference will be adjourned to May 28th, 2026, 9 a.m. Bond will continue.
Thank you.
Here. Court calls case, People versus Kimberly Douglas.
Morning, Your Honor. Ashley Feltus for the people.
And assistant public defender, Jay Bellinger, on behalf of Ms. Douglas, who is approaching, Your Honor. Ms. Douglas, can you please state your name?
Kimberly C. Douglas.
Thank you.
And Your Honor, we have somewhat of a tentative offer being worked out, and part of it depends on whether she gets into recovery court and the circuit court on one of her matters. So we are just asking for an adjournment. I did follow up with the recovery court, so they are in the process of reviewing her files.
That's not coming through this case, but
Correct,
okay.
correct.
So how much time do you think?
I would think a couple weeks should hopefully be sufficient to get her evaluated at this point.
Okay,
I see it's 2 cases open at circuit court, so it needs to be good.
okay. 2 weeks. June 4th, 2026, 9 a.m.
Okay.
Bond will continue.
All right, thank you very much.
Court calls case, People versus Melinda Baker.
Fellows for the people.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Baker, Your Honor, who I believe is here via Zoom.
Here she is. State your name.
Melinda Baker.
Thank you.
Your Honor, I've had a chance to discuss this matter with Ms. Baker. She wishes to set this for a preliminary examination.
All right. Agreed.
To the best of my knowledge, Judge, yes.
All right. And we'll have the witnesses of it.
We can try for that day. Thank you, Your Honor.
All right. Preliminary examination will be June 2nd, 2026, 9 a.m. before Judge Washington.
Thank you.
Thank you. Bond continued. Thank you, Ms. Baker. That is an in-person proceeding, ma'am.
Okay, thank you.
For the record, I have explained that to her, Judge.
Court does call the case of the people of the state of Michigan versus Danette Clay Brown.
People, Your Honor.
Morning, Your Honor. Charlotte Steffen, appointed counsel for Ms. Claybron. It's my understanding that this
Examination for May 26, 2026 at 9 a.m. That's before me. I will also order that the Ms. Weldon, if I can get an order, that the tether condition will be removed.
Thank you, Your Honor.
Defendant, my understanding, has already posted the monetary amount.
That's correct.
I'm relieving her of the tether provision. Here, you go. Okay.
Thank you very much, Your Honor.
Thank you.
Now, I'll be right away. Court calls the case, People versus Garcia Bravo.
This GOS in here.
Did I? Oh, I did. Because it's. Hang on a second. I read that wrong. It is. They scratched out, they whited over the thing. Jacqueline Bravo Garcia is what I have.
Assistant Public Defender Davi Liba for Ms. Bravo Garcia.
Any news on her?
Well, I thought she was on Zoom, Your Honor. I would ask her to consider passing the matter if I could give her a quick
Zoom. Bravo Garcia. Not on Zoom. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 cash surety.
Thank you, Your Honor.
Warrant will issue immediately. Court calls case, People versus Jason Haidu Banks.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Mark Creek on behalf of Mr. Haidu Banks. He's
right.
Oh,
Your name, sir?
Oscar Haidu Banks.
Thank you. What are we doing?
Your Honor, we'd like to have a short adjournment of 1 week. I have received all the discovery. I did drop it off at the county jail this week. And I did have a little time to talk about it with him yesterday, but I'd like to go over it in more detail.
That objection, May 28, 2026, 9 a.m. Bond continued.
Right.
Court calls case, People versus Michael Brown.
Assistant Public Defender Davi Liba for Mr. Brown.
Your name? Thank you. Take your hands out of your pockets.
And Your Honor, or Mr. Brown has substance use assessment scheduled for Friday. I'd be asking for.
Pardon?
He has a substance use assessment scheduled for Friday. I'd be asking for adjournment so you can complete that.
Hearing the matter to June 11, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue.
Thank you.
Oh, what you lost. Court calls case People versus Daryl Cope.
Morning, Your Honor. Marcia Critic on behalf of Mr. Croce.
Daryl Cole.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Pope and the other matters.
Your Honor, in my matter, which I believe is the 1077 matter, we'd be asking the court to proceed to exam discovery is complete.
Likewise in the other two matters.
All right, we're ready. Can I have a same second? Okay. People have their witnesses available on the second. Preliminary examination in person, June 2nd, 2026, 9 a.m. That's before Judge Ferry.
Thank you, Your Honor.
Thank you.
All right. Thank you. All right. Court calls case People versus Ashley Burke.
La la la. La la.
La la. What? What? Is this your
Morning.
case or are you stalling? You're stalling.
Good morning.
You are stalling.
It's a beautiful Thursday morning.
And I am here on this beautiful Thursday morning to represent Ms. Brick. That's Plug Fender Davi Lee before Ashley Brick. Thank you for your patience.
Oh, I didn't have any patience. I couldn't do anything. And you need to thank your colleague for
Thank you. And
state your name.
Ashley Burke.
Thank you, ma'am.
Yep.
And Your Honor, we're going to be requesting an adjournment in order to get some mitigation material.
For mitigation.
Yes, Your Honor.
Adjourn the matter June 11, 2026, 9 a.m.
Thank you.
Court calls case People versus Alan Fuqua.
Ready, Your Honor.
No, for the piece of the
Morning. Morning, I'm Robert J. Kill on behalf of Mr. Fuqua. Approaching the podium. Fuqua. Judge, I was just appointed, but I did meet with Mr. Fuqua yesterday for a good hour and a half. I know what the situation is. I have all discovery. We want to
Have it all.
want to set this for exam.
All right. People have their witnesses available the second. All right.
Judge, may I address bond?
Yes. Preliminary examination in this matter will be set for June 2nd, 2026, 9 a.m. before Judge Washington. All right, go ahead, Bond.
Just very briefly, my client was driving, he had just bought this older pickup truck, did not have a plate, which was the reason for the stop. He does have a valid license. That being said, he was pulled over, he was cooperative with the police. In the back of the pickup truck in the bed, which had it tarp covered, they found a pistol. It did not belong to my client. He did not know it was there. There was also ammunition that was not correct for that gun inside the cab, which my client admitted having. That being said, sole caretaker of his mother, actually Trinity Health, his mother's caretaker. She now lives in an apartment temporarily while the house they did live in caught on fire and is being rebuilt. All that being said, Judge, I'm asking if
Going to be an objection to release them.
There would be. The people are greatly concerned given the allegations in this case. The firearm that was found was a protected gun.
Was what?
The gun, meaning there's no ability to track it. There could be the ability to have some additional firearms in the future. The ammo did not match the gun. That could suggest that there was an additional firearm that was not found. The ammunition that was found were hollow point bullets, meaning that they would cause grave bodily injury if they were shot at a person. The defendant.
But not illegal. Okay, go ahead.
The defendant was an initial offender by 1988. He has 3 convictions for homosexual conduct second.
When was his last conviction?
2000. In 2000, he spent 18 years in prison, Judge. He's been on parole since 2018. Judge, I got off. He was off parole in 2018. I'm sorry. I'm just asking for, he did show the officer that the title, the guy did sign off on the title, just hadn't got a plate yet. Again, I'm asking more just for leniency because this is sole care.
Just buy the truck? Is that the deal?
Yes, Your Honor. It was a used truck. He had just bought it. Yeah, the person signed off the title. Again, because he's a sole caretaker of his mother who's temporarily living in an apartment while their house is being built. He's agreeable to home confinement, tether, anything the court wants to give because he's going to stay there with his mother while he takes care of her.
He's not currently on parole.
Correct.
When was his last conviction 25 years ago? Or longer than that?
Yes, Your Honor.
No information to speak that it's.
Well, look at your bond form. It says he's a convicted felon, heavily assaulted, dangerous criminal history, but so I'm trying to figure out why the magistrate set a $250,000 bond on this case. And it seems that that's the basis for it. But my understanding, at least as of now, is that was over 25 years ago. Or the conviction actually may have been before that, but 25 years ago. And he has no convictions in those 25 years.
I'm being told the date was 2003, but so it would be.
Okay, so 24 years ago or 20, whatever.
Judge, to be honest with the court, he was in prison for almost 15 years. He was released. He got off parole. He was paroled. He's got off.
When did he get off parole?
2018.
And hasn't had anything since?
No, Your Honor.
Where does he reside? In Ipsy?
It's temporarily, Your Honor, with he and his mother would be staying at, I think, what's the address? 910 Maplewood, apartment 2, while they're home on what street?
789 Calder.
Calder's being rebuilt, Your Honor, which should be done in the next couple months.
What is his temporary address?
The temporary address is
910.
No, who's there?
Just his mother.
So that's his mother's address.
Correct. And he's a caretaker for her, being paid by Trinity Health. I dropped a piece of paper.
Anything else?
No, Your Honor.
All right, I set it for exam on the 2nd. I'm going to release the defendant on $25,000 personal recognizance bond. However, a condition of that bond is he's to be placed on a home confinement GPS tether.
Thank you, Your Honor.
Thank you.
Okay, soon as you soon won't be released to that age. Then you have to stay at your mom's place, okay? All right, you take care and we'll
Court calls the case, People versus Kanga.
Please state your name for the record, sir.
Stevie Kinga.
Kanga, apologies. Your Honor, I did speak to Mr. Kanga. He has asked that we adjourn this matter to review discovery and talk to the about a potential resolution. If, I don't know if the court was gonna do the June 2nd date, Mr.
For what?
For his next date, Judge.
Why would I do, he's not asking for an exam.
Okay, just want to make sure. No, Judge, not.
Why?
He just-
Why are you, why is he doing this?
I'm talking too much. I'm sorry, Judge.
I know.
I'm done talking.
Jeez.
My apologies.
I'd be done by now, but go ahead, Feaster. I'll wait.
Just to say, Judge, I apologize.
Oh, no, you're not apologize. Don't extend it.
Whatever date you want, Judge.
I know. You were stopping me before I even said anything.
I shouldn't have.
Then gave the wrong date.
I did.
And then
we all make mistakes, Judge.
You see?
I'm sorry.
This is what I was talking about before I came.
My greatest apology.
Somebody is trying to pressure me to like.
No,
you're doing that to me.
I'm sorry. I didn't mean to.
No, I expected it from Chinaza, not you.
You're right. She does that all the time.
I know. All right.
Whatever piece of date you want, Judge. I'm sorry.
I know.
I'm done talking.
Yeah, stop talking. Sir, will June 11th work for you?
Yes, Your Honor.
All right, very good. We got all through that. PCC will be adjourned June 11th, 2026, 9 a.m.
Your Honor.
Thank you, sir.
Apologies, Judge.
No, why do you apologize when you don't mean it? Court calls the case, People versus Amasio McIntyre.
People, Your Honor.
Morning, Your Honor. Sam Bernstein with on behalf of Mr. McIntyre. McIntyre, can you please state your name for the court?
Mazio McIntyre. Thank you.
You're under arrest in the court to please set this for preliminary examination. Discovery is complete.
People have their witnesses available the second. All right. Preliminary examination, June 2nd, 2026, 9 a.m. before Judge Perry. Thank you. Bond continues. Court calls case of the People versus Jonathan Carey. Yeah. Boy.
Ready-ish? Portia Feaster, Assistant Public Defender, on behalf of Mr. Jonathan Carey.
You're on a date like Cannon.
Yes. Oh, I see him.
I've never seen you so excited.
Yes.
Sir,
Jonathan
take your
Carey.
name, please. Thank you.
Yes, sir.
You made Mr. Feaster the happiest guy in the world. All right.
I believe we're waiting for a video, Your Honor, from the bank in this case.
I'll adjourn this probable cause conference to June 11th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, Aaron.
Thank you for being here.
Yes, sir.
Court calls the case, People versus Stefan Scott. I said that.
We have people, Your Honor.
Here I Goldstein, appearing on behalf of the defendant. There you are.
Your name, sir?
Stefan Scott. Your Honor, at this point, I have received no discovery.
I don't think we had an appearance entered in our system, so I told Mr. Goldstein to inform me the appearance of momentary so within stay.
Well, Your Honor, that may be true that they may not have a written appearance, but I have spoken to Ms. Tenhouse several times and asked her for discovery, and I have not received it. Nothing to do with Ms. Enda, but
Comes me against the house.
Sir, well, but my understanding is it's sort of an automated process. Once it's sent in, the discovery's then sent out.
Last we had it sent, I believe, was to Mr. Kilwall when he was originally on before Mr. Goldstein got back. Okay.
If Mr. Kilowall doesn't have it, I'll tell you, because I asked him for
He
it.
doesn't have it?
No.
I think we found a USB because there is over 1,600 pages of discovery, and then each of those is like separate police reports. I believe it's on a USB at our office.
You're right. I don't have a problem with an adjournment. I did file a green sheet, but I just want
No, I know. But I also want to make sure I don't get back here and then we don't. Because if Mr. Kilowall didn't have it, if it's on a USB, that may be because he might not have picked it up, but I want to make sure that it's failing.
The problem is this case went from A to B to C to D. I'm the D. Mr. Kilowall was either the B or the C. He kept switching to different people, which is one of the reasons why it took a while to get the substitution done. Because we were always one step behind, but.
Got it.
So if it's not entirely your office.
Because I still have, I have Mr. Goldstein now on the case.
Yeah.
Okay, so I guess I want to make sure the discovery is going to be available for pickup.
Yes, I believe Mr. Moses needs to bring a USB with him, and we have it ready to copy over.
How big a USB? You know what? I've got an external drive that holds a lot. Yeah. Okay.
Okay, good. We got all the technical stuff worked out?
Yeah. Now comes the fun part, Your Honor, which is the issue of bond.
It might be fun for you.
If I can.
How long an adjournment did you want?
Well, I'm going to be gone the month of June, so I'm talking about early July.
Okay. Can do July 2nd, is that right?
Hang on, let me check. I think that's good, but let me check. I'll make it work, Your Honor.
All right.
Now, on the
double cause conference will be adjourned. I'm trying to avoid.
I know you are.
That's basic.
You're doing a good job.
I know. All right.
All right, I'll try to make this as brief as possible. 14 months ago, my client was charged with some charges. Those charges were pending until about a month ago, when on the eve of trial, prosecutor's office nollie prossed, and then turned around and filed the charges you have in front of you. None of them are new. All these dates go back to early 2025. So he basically sat in jail for a year. They then dismissed it and charged him with things they could have charged him over a year ago. Now we come to do the probable cause conference, and there's no discovery. Now, it's not their fault I'm on vacation next month, but it's going to be another 4 or 5, 6 weeks before we can get back into this court and we can start moving forward. And none of this was at Mr. Scott's insistence. He was ready to go to trial all the way through. And the case kept sitting, and then they walk in and dismiss it. And I'm not going to argue the issue whether he's entitled to credit, because that's not for you to decide. But one of the consequences of him sitting for a year was that nothing happened, and B, he could now lose the credit for that year.
But so that I'm from the people, so that I'm clear, the original charges that he was sitting, did he have an exam on that case?
I wasn't representing him at the time, Your Honor, so he did. Yes, he did.
So he had an exam, was bound over, waiting to get to trial, and then at the point of trial,
they nollie prossed. And some of those charges that they nollie prossed are included in the the complaint that's in front of you now. And then there are additional charges, but those additional charges could have been brought a year ago. And they chose to wait a year and not charge them. So at this point, Your Honor, I think it's only fair that he.
Well, but hold it.
Okay.
You're saying they could have been brought, so they didn't arise.
No.
Okay.
In fact, if Bernstein is still here, he represented Mr. Scott at the time. They even argued some of those at the time of the bind over, but they were not added as charges. None of this is new. If you look at the dates in your complaint,
They argued it, they weren't added.
they tried to get in some testimony at the preliminary examination. Some of the same information some of the same charges that are contained in the complaint that you have, and Judge Barr would not allow it. But they never moved to amend or bring those charges until April of 2026, a year later. So the case sat for a year, and those charges could have been brought either as an amendment to the information or as a separate case, and they didn't do it.
Response.
I did not handle that exam for the previous case. He was previously charged, I believe, with ag stalking. And at that exam, the victim did appear and testify. And after that exam, after speaking with her, it's my understanding that our office had Detective Pearson or Soaring do a supplemental interview with her to go back over the entire history of their relationship and the domestic violence that occurred within that relationship for a potential new case that was submitted. That case was submitted, and that report was, I believe, 1,600 or so pages that Ms. Tanner had to review and go through and speak with the victim about before deciding what charges were going to be issued. And in that report, it does detail the 5.5-year relationship and numerous acts of domestic violence, including times that the victim was seriously physically assaulted to the point of having injuries and being assaulted while holding her child, thrown in a closet and choked. The child was taken to the hospital for weeks. There's other assaults that are detailed here that include her suffering extensive bruising, bleeding, difficulty walking, incidents of the defendant being at her house when police arrived, him telling her not to contact police and to tell them that everything is fine and have him come out after they leave, incidents of the defendant contacting her, along with this extensive history, points which the defendant was incarcerated on those previous cases that she did not appear for because of him intimidating or interfering with these cases. There was thousands of jail calls. I think at the end of that supplement report, what was submitted was a call log that included 1,004 completed calls during the pendency of those previous cases to the victim that were included in that report as well. So this is an extensive review of that entire domestic violence relationship, including potential for sex trafficking charges for this victim as well. I mean, it's just an extensive history of violence and aggression and abuse that this victim faced that we needed to sift through with her and the detective to get a full picture of what potential charges could even be coming for this case.
Your Honor, it's a little unfair for her to give this litany of things for two reasons. One of which, this is neither the prelim nor a trial. And number two, I can't respond because I have not seen any of that material. So I think it's a little unfair for that to be brought up. You can see what the charges are. You've got the complaint in front of you. You can see the dates of the alleged offenses. And Ms. Enda has now indicated, yeah, they've had this information for a year now and did nothing. And it's just, so he basically was asked to give a year of his life while they twiddled their thumbs.
No, because that's not entirely true, Mr. Goldstein. I mean, at least the way that you make it seem, because he had a prelim and was bound over on the prelim. Now, as to what court scheduling or anything else along those lines, I can't speak to that. I mean, I get it that he's there, but then they come in and they dismiss the charges, but then they bring these back.
I mean, the only thing I disagree with what you just said, Your Honor, is they could have brought these charges a year ago. And now we're starting all over.
I mean, I hear what you're saying, but I don't know that. I don't know how ripe the charges were. I can't say that. Or whether or not they had all of the information. I mean, I hear what you're saying and that they requested that some of these be added, but.
Yeah, that's really as well from my review of our notes. What an extent of what this is was discussed, but it was not the full extent of the sit down. I believe the interview was like 4 or 5 hours with this victim going over this history. We did not have that the day of the exam being up.
That's correct, Your Honor. But when was the interview? It was done within days of the exam. And they certainly knew some of this
after the exam. Which means he
some of it, yeah.
Not, right. I mean, okay.
Yeah, that's correct. That's correct.
Which means they couldn't have just added them because he would have been entitled to an exam on any added charges anyway.
Right, and he added charges. There's some information they already had, some information they got later. I can see that.
Well, okay, anything else? At this point, I mean, certainly I would hear anything or get this thing set, but the discovery is now ready, given the adjourned date. At this point, however, I'm going to deny the motion for reduction in bond. His bond will continue as is. And certainly feel free to address it once you've looked at the discovery on July 2nd. Then. All right. Thank you. Court calls the case, People versus Josiah Miller. Got it.
I actually felt this for the people, just I know it.
David I. Goldstein appearing on behalf of the defendant.
I see the waiver signed here, but I don't have him.
No, Your Honor.
They have not signed.
I anticipated him being here because it was confirmed. One thing was confirmed, which was that the writ was issued and sent. What was unconfirmed is they never responded. Hillsdale County never responded. So.
And you're gone in.
Your Honor, I mean, I ask a favor of the court if the court would consider it. I realized that July. No? Okay.
No. Oh, good.
Judge, I realize June 2nd is a prelim day. I don't know if you're going to be here on the 2nd because
I'm here, but I'm not holding them on the 2nd. But you're out June 4th.
I'm out after the 4th, right, Your Honor? I mean, I'm sorry, I'm leaving on the 4th.
You're leaving
wait a minute, you know what? I'm leaving it on the evening of the 4th. I can be here on the 4th.
Okay, then I can set it to 4th. That'll give another 2 weeks out.
Perfect.
And for probable cause June 4th, 2026, 9 a.m. See, I have a comment. All right, I've accommodated Mr. Goldstein and didn't have to do a favor.
I'll probably by Zoom, but you've got the written waiver in the file.
Got it. Court calls the case, People versus Elijah Hudson.
Alexander, on behalf of the people, Your Honor.
Judge Simpson, he'll be right with you. Once
I'm sorry.
he'll be right with you in 1 second.
Okay. I'm good.
Apologize, Your Honor. For the
All
record, Burkett, on behalf of the defendant here, Your Honor.
Thank you. State your name, sir. Okay, what are we doing on this case?
Yeah, I just received a discovery in this case. Notice there are some things missing. I was going to ask for a 2-week adjournment of the probable cause hearing.
Without objection, probable cause hearing will be adjourned to June 4th, 2026, 9 a.m. Bond will continue. All right, thank you.
No.
Court calls case of the People versus Mario Crawford.
Your Honor, bring it to the people.
Stephanie Cannon on behalf of Mr. Crawford, but not with, Your Honor. I would ask for an adjournment.
You expect by looking back, he's going to miraculously appear?
No, I was waiting.
What? No, I'll wait, Cannon.
I was looking for the APA to make their statement after my request for an adjournment. That was all, Your Honor.
After, they don't need a statement.
I know, but
it's not here.
Yeah, I know you.
I mean, they can make a statement. It's probably bench warrant.
I'm not. I don't believe Mr. Cook would ever do that, Your Honor. I just.
Yes, would. He absolutely would. All right. Bench warrant will issue for defendant's failure to appear on both cases. Bond 10,000, cash surety.
Thank you, Your Honor.
I know you mean it. Thank you. Ouch. That's a problem. Court does call the case, People versus Wesley Brand.
Michael Gaddy is public defender on behalf of Mr.
Your name, sir? Wesley Brand. All right.
Your Honor, I do, I'm sorry. Your Honor, I do have a green sheet. We are asking for a brief adjournment. There is there might be go involved.
That's correct, Your Honor. Mr. Gaddy, I spoke about that this morning. I understand it's raised how much.
That is correct, Judge.
He's held on another case. Probable cause conference then will be adjourned. Is it a lot of video that you gotta?
It's related to the soul that's this, on a corrections employee, so I just need to get it from.
Get it.
Number, all those things, so I don't know how many videos, but I think 2 should be enough.
June 4th. 2026 next. Thank you. That's, I know.
Thank you, Judge.
I don't know. Okay. We'll see. It's not gonna. Court calls the case, People versus Muhammad Dari.
Ring cook for the people.
And good morning, Your Honor. Assistant Public Defender, Shanazi Kiriak Ruby, on behalf of Mr. Mohammed Dari, who's approaching. Mr. Dari, could you state your name for the record, please?
Dari.
Your Honor, we're asking for an adjournment in this matter. We adjourned previously for mitigation. I've spoken with my team and they need just a little bit more time.
Their green sheet. Really? Who has it? Miracles never cease. June 11, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
You need a paper?
Wow, now I can say, oh, thank you. Court does call the case, People versus Michael Bird.
And on behalf of people, Your Honor.
I just tell her.
Stephanie Cannon on behalf of Mr. Berg. Mr. Berg, could you please state your name for the court?
Michael Birch. Thank you.
Your Honor, we're asking that this be set for preliminary exam.
Discovery is complete.
To the best of my knowledge.
Are there witnesses available to second?
For best, Your Honor.
Preliminary examination, June 2nd, 2026, 9 a.m. before Judge
Washington.
Washington.
Thank you, Your Honor.
It was a fix of desperation.
Oh, Jason.
Just call the case of the People versus Robert Davis.
People.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Davis. Approaches.
State your name. Robert Davis.
Your Honor, I have gone over Mr. Davis's right to a preliminary examination, which is to, right?
You saw those in the Wizard of Oz. No, go ahead. I'm just messing with you. All right.
Just to waive his exam and seek, there's no promises, but to see possible height of resolution in circuit court.
Davis, is that correct? You're waiving?
Yes, sir.
All right. You understand that a preliminary examination is where the people would have to show by probable cause that offense alleged was committed and committed it. Understand that you'll not have that hearing and you'll proceed to circuit court for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Gaddy.
Your Honor, we would waive reading stand mute.
Defendant having waived former reading standing mute, court will enter a not guilty plea. Pre-trial in this matter will be set for July 15, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you, sir. Telling you. Court calls the case. People versus Vasquez Davis.
And good morning, Your Honor. I'm the public defender tonight.
How you doing today?
I'm great. How are you?
Vasquez Davis. Vasquez, state your name for the record.
My name is Vasquez Davis, sir.
Yeah.
How you doing today, sir?
I'm doing wonderful. How about you?
I'm good, man.
Are you? I'm glad.
Judge, you're asking for an.
How you doing?
I am doing well.
All right.
Oh,
All right.
We'll smile.
On there.
Judge, you're asking for an adjournment. We have heard that Mr. Vasquez is headed over to Oakdale. So, we're working on
Oh,
patient and we want to see if we can get a successful completion of that and hopefully everything ties together.
okay. You heard, do you know, we have a timing on any of that or?
She has not, Sarah Stewart has already sent information to Judge Judge Garwood, thank you, at 15th. She's just waiting on them to sign off on it. So hopefully within the week.
Okay. And is this the only thing he's held on?
No, Your Honor. In fact, he's not held on this matter. He's held on the 15th matter. So the next thing we wanted to address was bond.
You want me to give him a bond?
We want a very low bond, correct? Because he's been in on here maybe about 3 weeks now, but been on PR on our case.
Got it. And then he goes to Oakdale, it's gonna be a minimum of 30.
That's right.
So why don't I, unless you have an objection, I was gonna put it to my last date in June
Okay.
and then see where is that? You understand that?
For sure.
Huh?
What you say, sir?
Were you listening to anything I said?
No, sir.
All right.
It's okay.
I appreciate your honesty.
Sure.
I'm gonna put your case out about a month or so because you're gonna be going to Oakdale. And it's gonna probably be a minimum of 30, so I'm just trying to time that out. Your counsel's asked that I give you, because you got a PR on this case, but that means you're not getting credit. So she's asked me to set a minimal bond on this case for you. You understand all that?
Sure. Right.
All right. So probable cause conference, I will adjourn to June 25th,
Okay.
2026, 9 a.m. I will grant I'll set his bond at $50 cash surety.
And I'll send over a piece to treatment on our case.
On this,
That's right. Yes.
all right. Okay, who you waving at?
My mom.
Where's your mom?
Right there in the back.
Looking.
Oh, hello. I'm doing fantastic. All right, young man.
All right.
You're headed out to treatment. Good luck to you.
Thank you, sir.
All right, take care.
All right. That's it.
Thank you, Judge.
Hey, well.
This is always out in the middle of the home.
Take care, ma'am. Court calls the case, People versus Amanda Dickinson.
I know. Assistant Public Defender Jay Bellinger on behalf of Ms. Dickinson, who should be appearing via Zoom, Your Honor.
What?
Should be on Zoom, Your Honor.
Hello, I
right.
can't figure out how to get the camera to work. Oh, never mind. Here it is. Hi.
Hello, can you state your name?
Amanda Dickinson.
All right.
And Your Honor, I just got word that we have received but not been able to yet download the CCTV footage in this case. So I am just asking for a brief adjournment so that we can review that before setting.
I'll adjourn it to June 11th, 2026, 9 a.m.
Thank you.
Thank you.
Thank you.
Court calls case People versus Maisha Gaines.
Mike, public defender on behalf of Ms. Gaines, Judge. Your Honor, I'm asking for,
Maisha Gaines.
Your Honor, I'm asking for a brief adjournment of this matter. I believe we do have a resolution. There's an ancillary matter in another jurisdiction I need to check on.
June 4th,
That's fine, Judge.
2026, 9 a.m. Court calls case People versus Amber Dunson.
I'm here.
That Mrs. Stell.
Who? What are you talking about?
Sorry, Your Honor, her name was entered incorrectly into Zoom and I wanted to make sure that wasn't a maiden name or something.
It was entered incorrectly by my staff?
I'm not blaming anyone. All right.
Assistant Public Defender, should I be?
Blaming you?
Yes.
He is?
Right. So.
Oh, don't say that. Don't save him.
That's because it's my fault. This man.
Okay. See?
Okay.
Go ahead. Miss.
Not the blame man.
So what are we doing?
Judge, we're asking for an adjournment in this matter. She's on Zoom. Amber,
know.
your name for the record.
Please.
Amber Dunson.
Thank you, Mayor.
Yes, Your Honor.
Adjourn it out to June 11th, 2026, 9 a.m.
Thank you, Judge.
Okay.
Okay.
This is the one. This is his case? I just don't want to call anything felon.
Aw.
Court calls case versus Amber Estelle.
People.
And Assistant Public Defender Jay Bellinger on behalf of Miss Estelle, who appears as Zoom.
Ma'am, could you state your name, please?
Amber Estelle.
All right.
And Your Honor, we are seeking.
Behringer had it all mixed up.
Oh,
Had it all straight. Don't worry about it.
that's cold. Did you just say Behringer?
Mm-hmm.
That's cold.
Call my staff out. I'll call it. All right.
Tell him.
You should hear the first thing I had.
Your Honor, we are seeking to waive today. My understanding is that with talking with Ms. Veltis is that we should be able to work out some sort of misdemeanor in circuit court upon her waiver into the Hillsdale Recovery Court.
Got it.
Correct, Your Honor. We're hopeful that we'll be able to agree that upon completion of that court, it will be reduced to a misdemeanor or potentially dismissed, but we need to have it happen in circuit court.
Got it. All right, ma'am, you're going to waive your right to preliminary examination?
Yes, Your Honor.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People also waive their rights. All right. Preliminary examination having been waived. Defendant is bound over to circuit court on both counts.
Your Honor, as to that, we acknowledge receipt of information, waive formal reading, and stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pre-trial will be set for
July 14th at 1:30 with Judge Compton.
July 14th, 2026, 1:30 before Judge Cumpy.
Thank you.
Thank you.
Thank you. Good luck to you, ma'am.
Thank you very much, Your Honor.
Bond continued. Court calls case of the people versus Samuel Platt.
Your Honor.
Why? How many does he have?
Assistant Public Defender Jay Bellinger on behalf of Mr. Platt. Mr. Platt, please state your name for the record. Samuel Platt.
Thank you, sir.
And Your Honor, at this time, we are seeking to set this matter for preliminary examination. To my knowledge, discovery is complete.
People have their witnesses available to second.
Yes, Your Honor.
Preliminary examination will be set June 2nd, 2026, 9 a.m. before
Judge Perry.
Judge Perry. Bond will continue. Thank you. Court calls the case, people versus Jovan Foster.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Foster,
Like I'm
who appears via Zoom. Mr. Foster, can you please state your name for the record?
Jovan Foster.
Thank you, sir.
And Your Honor, at this time, we are seeking to set this matter for preliminary examination. To my knowledge, all discovery is complete. My understanding is that we are not getting CCTV footage from this incident.
Got it. People have their witnesses available to second.
We'll do our best, Your Honor.
All right. Preliminary examination will be June 2nd, 2026, 9 a.m. before Judge Washington. Court calls case, people versus Taft.
I'm just kidding. I'll leave.
Assistant Postmaster Davi Lieb on behalf of Mr. Taft.
Your name, sir?
Justin Taft.
Thank you.
Andrew, I'd like to request an adjournment for Mr. Taft to make some progress in treatment, which Ms. Feltis indicated to be not oppose a release to.
You may recall Mr. Taft was the person who was looking to go do treatment in Detroit.
Yes.
Veterans treatments, and
Yeah.
we've been able to figure that out. So I'm stipulating to that to get him out to go to treatment, and hopefully we can resolve this case once he does a little bit of progress there.
Got it. What's our timing on all of that?
Your Honor, he has an admission scheduled on the 27th. So my request to the court was that he was going to be released with a tether either the night of the 26th or the morning of the 27th.
So he goes into treatment on 27.
Yes, Your Honor, and I received an email from the
We
that effect.
we don't know how much.
No, I think it's for once at least a few weeks.
They indicated at least 30 days.
Gotcha. Okay. Since it's going to be a PR to treatment. We're going to just be short. But what I'll do is I'll adjourn it out to June 25th. If it looks like he hasn't completed it quite yet, but I'll adjourn it out by step
That sounds great.
to the next day.
Thank
All
you.
right.
Thank you, Your Honor.
All right. Thank you. Good luck to you, sir.
And Your Honor, do I need to submit an order regarding the release to treatment?
Yes.
Thank you, I will do so.
Court calls the case. We have People versus Taylor Godfrey.
Raymond Cook for the people.
The public defenders now be here. I can really, Your Honor, on behalf of Taylor Godfrey, who's approaching. What's down for you? Let me say your name for the record, please.
Taylor Godfrey.
Thank you, ma'am.
Your Honor, we're asking for a brief adjournment. We finalized.
I'm sorry.
We finalized our negotiation.
Oh, did you see that? She put her hand on her head. Her neck kind of crooked, put her hand. That was going to intimidate me. I will not be intimidated. Go ahead. I'm sorry. I interrupted.
That's okay, Judge. We have finalized everything. We decided on a no contest plea, so we just need time.
Oh, you just need time to.
That's correct. It's
Can you get it by the 28th or you want the 4th?
any date the court gives us. We've already submitted everything to.
Wow. Doesn't happen that way. Let's try to get it done next week. Okay. May 28th,
Next week's good. Yes.
2026, 9 a.m. Bond will.
Judge.
Thank you. Thank you. Court calls case. People versus Kelly Walker.
People.
Assistant Public Defender, Shinazi Perry Akinruli, Your Honor, on behalf of Ms. Kelly Walker, who's approaching. Kelly, state your name for the record.
Kelly Walker.
Your Honor, we respectfully request that this matter be set for preliminary examination, please.
Discovery is complete.
To our knowledge, Judge.
People have their witnesses available to second.
I'm checking both pieces now, Your Honor. We'll try for those dates. Thank you.
All right. Preliminary examination in person, June 2nd, 2026, 9 a.m. before Judge
Perry.
Perry.
Your Honor.
Thank you, Your Honor.
Bond will continue. That was my last.
There's a guy down here who's refusing, but
Okay.
that was your last. There's a guy down here who's refusing.
You went back knowing you weren't allowed there? The judge exploded after a defendant admitted he repeatedly returned to his ex's home despite strict no-contact bond conditions. The man tried defending himself by claiming she kept inviting him back, even giving him a key and asking him to pick up his belongings. But the judge wasn't interested in the excuses. Prosecutors revealed Ring camera footage allegedly showed the defendant showing up multiple times, knocking on doors and bedroom windows, calling nonstop, and even confronting the woman outside court. The prosecutor warned the court that the situation was escalating and asked for his bond to be revoked immediately. The defendant insisted the relationship was toxic on both sides and claimed he only returned because the woman kept reaching out first. At one point, he desperately told the judge, "She asked me to come back half a dozen times." But the judge fired back with a brutal reality check. "That is not why you're here today. You violated your bond conditions." Then came the line that completely shut the courtroom down. How many times does a woman have to screw you over before you just start ignoring her? Seconds later, the judge revoked the man's bond and sent him back into custody. Do you think the judge made the right call? Or was the defendant being set up? Ooh.